Hello members of the Court of Public Opinion. I am your girl Mrs. Independent, aka I am not a lawyer. So today we heard that the Pretoria High Court has ordered that accused number 3, Mthobisi Mncube, in the SENZO MEYIWA trial be released from solitary confinement. Solitary confinement is illegal, and you ask yourself, why is it still happening in South Africa in 30 years of democracy? All is not lost. Let's unpack the judgment from Judge Jan SWANEPOEL. Oh, Amanga, you know, it's good to Mthobisi would serve crime, would serve sentence for crime that he did, but let him not be a scapegoat for anything else. So why would the respondent lie? Let's say correctional services, why would they lie and say Mncube came and want to dispose supplementary affidavit when they know they lie? Listen to what judge said.
Preliminary matter, I wish to deal with the parties' attempts to introduce new evidence at the last minute. When the matter came before me on Wednesday, 6 November, the respondent's counsel, Mr. Madiba, complained that the applicants had attempted to introduce new affidavits shortly before the matter was called. I pointed out that there was no application before me explaining why it was necessary to introduce new evidence at such a late stage, and that I would consequently not take heed of the applicant's proposed supplementary affidavit. The matter then stood down until Friday, 8 November for argument.
So now you see the monkey tricks that are being played. Hi, Lalamzans. You know, when you are in power, don't be arrogant. Do not be arrogant, because people...
Respondent suddenly wanted to introduce further affidavits. As with the applicant, there was no substantive application to supplement the respondent. The respondent could provide no explanation why the information in the proposed affidavit, some of which was already known to the respondents a year ago, had not been included in the answering affidavit. I took the view that what was good for the goose was good for the gander, and I declined to admit any further affidavits from the respondent.
Everyone has learned the cooking process. Now they wanted to give supplementary affidavit, yet they were complaining that Mthobisi Mncube wanted to give supplementary affidavit. But the judge, I like it. I hope Judge Rata would take a leaf from this, from Jan SWANEPOEL's book. No piecemeal information, no backdoor evidence, no new information, no corrections, no nothing.
The respondents have argued that the matter is not urgent. They say so on two grounds. Firstly, the applicants have been imprisoned in these same circumstances for a long time, in the case of the first applicant for years, and any urgency, the respondents say, is self-created. Secondly, argue that it would make no difference to the applicants if they were detained at CMAX until the review application in Part B is heard.
So it makes no difference if by keeper or they remain there, and apparently solitary units are expensive to run, and it is bad for us as taxpayers. Okay.
Although the first applicant says that his incarceration amounts to torture in terms of Rule 43 of the United Nations Standard Minimum Rules for the Treatment of Prisoners, the so-called Nelson Mandela Rules, his case really hinges on the allegation that his further incarceration at CMAX is in conflict with the respondent's own standard operating procedures that only allow for the incarceration of a prisoner in CMAX for 18 months, save in certain exceptional circumstances.
What is the purpose of solitary confinement? If they say it's 18 months, after 18 months, what happens? If your behavior doesn't change, if inkani sasekhona, what happens after 18 months? Because now it contradicts your operating standard procedure. Okay, let's continue listening to the judge.
The first applicant has years. In my view, if a prisoner is incarcerated unlawfully, an application to rectify the position is inherently urgent. I will deal here under with the averment that the first applicant is unlawfully incarcerated. The first applicant has also alleged that the conditions under which he is incarcerated have caused him to suffer a mental breakdown. The allegation is denied by the respondents in a perfunctory manner, but they have made no effort to investigate the first applicant's complaints. They do not believe that the first applicant's averment should be rejected out of hand. I find that, as far as the first applicant is concerned, the matter is urgent. The same allegations, specifically, the respondents say that twice per month. The respondents deny the first applicant's allegations, specifically for an hour, twice per month. The respondents deny the first applicant's allegations. Respondents deny the first applicant's allegations. Specifically, the respondents say that the applicants are not in solitary confinement or in segregation. This is semantics. If the circumstances amount to solitary confinement or segregation, call it what you will, remains solitary confinement or segregation.
Uyayizwa mkhuba. I wonder kovela wabona ke ma, if they say they deny solitary confinement, they say it's segregation, but the judge said it's only semantics. Call it whatever you want it, but according to my eyes, segregation, solitary confinement, if the circumstances amount to that, it is what it is.
As mental health challenges are concerned, the respondents take a rather supine attitude. They say that if he has such problems, which they deny, he could have approached all manner of specialists. Considering that the Act places an obligation upon correctional services to see to a prisoner's well-being, the rather no-care attitude of the respondents is alarming. However, as I have said, I do not intend to make regarding the circumstances in CMAX. That is for the reviewing court to consider, and I will not tread outside the ambit of this application for interim relief.
Judge, the I don't care attitude. They didn't do anything. They forgot about their obligation as Department of Correctional Services that is upon them to make sure that whoever is incarcerated, their well-being is kept and it's safe.
Cannot be said for the second applicant. Although he says that he is also the victim of the same allegedly inhumane circumstances in CMAX, his continued incarceration falls within the four walls of the Correctional Services Act of 1998. The second applicant has been in CMAX for a little over a year. Self-created, in that it had apparently taken the applicant months that he was being tortured. The applicant's delay in bringing the application timeously was therefore fatal to the matter, and the application was struck from the roll.
This is where we end it. Thank you so much for your support. Remember to subscribe, like, share, and comment on the video. Until the next one, bye.